Hello everyone, welcome to PW OnlyIAS. As usual, we are here with the 7th chapter of Indian Polity, that is citizenship. So before we head on with our chapter, very quickly, this is my Telegram channel, people. Any queries that you have, you may post it over here. You can even send your PYQs in the PDF format from 2013 onwards into this channel. Even if you have any other doubts also, you can post it over here because this is the platform to contact me directly. Now, without any further delay, heading on with our discussion, let us understand the meaning and significance of being a citizen of a country. So, citizens are full members of the state and they owe allegiance to it. That is, when you say you owe allegiance, means you are bound by the rules of that country. That is how it is generally for any citizen of any country. Aliens are citizens of another state and they do not enjoy all civil and political rights. Aliens means you are not the citizen, you belong to another country and they don't enjoy all the rights. Aliens, again, there are two types. There are friendly aliens and there are enemy aliens. Friendly aliens means they are people of another country with which we don't have any outstanding issues generally. Then there are enemy aliens. Enemy aliens, when we say, generally we use that terminology, especially if you are in a state of war with another country. That is, tomorrow, let us say, worst case scenario, a war breaks out between India and Pakistan. In such a situation, citizens of Pakistan will not be just considered as aliens in the country, they'll be considered as enemy aliens. Because there is a chance that they may work against India while they are staying inside India. And that is also the reason why enemy aliens are not protected by Article 22, that is arrest and detention. When there is an outstanding issue between India and Pakistan, let us say a conflict broke out. In such a scenario, all the citizens of Pakistan who are inside India, legally only, they are inside India legally, maybe they would have come with a visa or something, they may have to leave the country quickly. And if they don't leave the country quickly within that stipulated time period, they will be arrested and they will be detained till the conflict is resolved. Apart from this, aliens do not enjoy Article 15, 16, 19, 29 and 30. And few more other rights are there which aliens don't enjoy. What is Article 15? Right against discrimination. They can be discriminated. Right to equality of opportunity in matters of public employment. Aliens cannot claim that they want to be part of UPSC or they want to write examination. No. Right to freedom of speech and expression, assembly, association, movement, residence and profession, that also they don't enjoy. They cannot simply move out anywhere in the territory of India. They cannot form any association of their choice, etc. Then obviously cultural and educational rights. They cannot claim that they want to protect their culture or they want to establish their system of education here. No. Right to vote plus right to contest elections, eligibility to hold public offices like president or prime minister, etc. Even that also there are certain restrictions. In this particular case, one interesting exception is there. In India, who can be a president? Anybody who is born in India as well as who has, maybe he was a foreigner, he or she was a foreigner initially, but later they got naturalized. That is, they have stayed inside India for a certain time period, after which they applied for citizenship and they got the citizenship. Such citizenship where you stay in India for a considerable period of time, then make the application, that is called a process of naturalization. What is this process whereby which through naturalization somebody gets a citizenship? We will see it in a while. But point here is, it is not necessary that you have to be born in India to be an Indian president. Whereas in USA, if you need to be the president of USA, you have to be born in USA. Getting the point here? President by birth and naturalization. In the case of India, for USA, it is only by birth. All right, people, moving on. Now let us see what do you mean by single citizenship. When we say single citizenship, one must understand we don't have separate citizenship for a state. Jammu and Kashmir initially used to enjoy that particular provision, but no more. We have already seen that in our earlier chapters also. By the order of 2019, it is over. It is done and dusted with. So we only have a single citizenship. That is, we are all the citizens of India. You don't say citizen of the state of Madhya Pradesh or the citizen of the state of UP. You don't ever say that. It's just that, okay, the person is from Uttar Pradesh. The person is from Madhya Pradesh. That's it. There is nothing called as a separate state citizenship. Let us get into it a little more in detail. There is no separate state citizenship like USA and Australia. In USA, you actually have dual citizenship. That is, you are basically a citizen of the state as well as that of the country. Some exceptions to the provisions of discrimination are there. That is, you are not, there is a fundamental right which clearly says that you are not supposed to discriminate against anybody on the basis of what? Caste, creed, sex, etc. But there are certain exceptions to it. Let us see. Residence can be kept as a criteria for certain jobs. That is, you have to be a resident of a particular region or a particular state if you need to apply for a job. This provision was there. For example, in the case of Public Employment Requirement as to Residence Act 1957, residential qualification for non-gazetted posts in Andhra Pradesh, Himachal Pradesh, Manipur and Tripura, which expired in 1974. Currently, this act is only applicable for Andhra Pradesh and Telangana. The reason is nothing much. It is basically backwardness. That is the reason why this exception was added. All right. Special concessions or benefits can be given according to Article 15. What do you mean by special concessions or benefits? That is, discrimination, positive discrimination is possible. Positive discrimination means a particular community or women or children, they are vulnerable. So to protect them, we give them certain special privileges. Then comes the exception under Article 19. As I have already discussed in the initial part of our discussion, it is not that anybody can move throughout freely, wherever they want, talk any nonsense they want. That is not the case. Reasonable restrictions can be placed even in the case of what? Article 19. Till 2019, Jammu and Kashmir was empowered to do the below. Let us see what they were empowered to do. Define who are the permanent residents of the state. Confer special rights and privileges on permanent citizens. That is, only the citizens of J&K. That simply means, I'll give you a simple example for that. When till 2019, the provision of J&K was such that, now me being a person from the state of Kerala, I cannot buy a property in Jammu and Kashmir in 2019. I cannot buy it. And if I would have got married to a Kashmiri woman, that Kashmiri woman will not get any property, or she's legally not entitled to get any property from her family. Got the point here? She won't get it. Those were the type of rules there. That means clearly a distinction is being made between citizens of Kashmir and the rest of India. That is how it was. And who was entitled to do it? The Jammu and Kashmir Legislative Assembly. They could decide things. Who are the permanent citizens? Who are the permanent residents there? All of this. And on the permanent citizens, the following rights were there. Employment under the state government, acquisition of immovable property, settlement in the state, right to scholarships and other aid provided by the government. That means clear discrimination. Only if you are a Jammu and Kashmir citizen, you will be able to buy the property. You will be able to apply for exams, apply for scholarships. These were the provisions given. But after the 2019 presidential order, all of these have been scrapped. And some of you who would have, if you have read the earlier Lakshmikant textbooks, you would have seen there, always there used to be a clause. And what was the clause? That this act is applicable everywhere except J&K. Except J&K. You would have read this in the earlier textbooks or in the earlier versions of any bill. But by 2019 order, what has happened is, whatever law is passed in India, it is applicable everywhere. There is no exception to J&K anymore. Clear, people? Moving on. Constitutional provisions. So let us see what are the constitutional provisions here as per citizenship. Citizenship, if you see, comes under Part 2, Article 5 to 11. It identifies citizens, persons who became citizens on 26 January 1950. That is the date on which the Constitution commenced. Does not deal with problem of acquisition or loss of citizenship. How to acquire citizenship or how do you end up losing citizenship, that is not discussed here. Parliament is empowered to make laws with regard to citizenship. Only the parliament. Keep it in mind. So these days, I'm not going to name any state particularly here, but again, many political parties as well as states is under this misconception that they can easily deny the central government. When central government is trying to pass the Citizenship Amendment Act or any act associated with citizenship, some states will say, no, we won't allow this rule to be passed here, etc. First of all, it is none of their business. As simple as it is. Constitution is very, very clear. Parliament alone has the right to pass laws in it. And if it is passed by the parliament, the states have no choice but to abide by it. Getting the point here? Some states are playing petty, puny politics with regard to this, but the law is very clear. Citizenship Act 1955 have been amended from time to time. That is the reality. This keeps getting revised. The years gets revised, the deadline gets revised, that is, and provisions of it, slight changes or fine tuning keeps happening. So let us see. So what are the conditions for citizenship? The person should be domiciled in India and should have fulfilled any one out of these three conditions. You are born in India or either of the parent is born in India. Resident for 5 years before the commencement of the Constitution, that is before 1950. Any one of the three conditions initially. You are inside India and any one of these conditions you have satisfied. You are born in India or either of the parents are born in India or resident for 5 years before the commencement of the Constitution. Moving on. Or migrated from Pakistan and became an Indian citizen. Now you are not domiciled. You migrated from Pakistan. You will become an Indian citizen if he or she was born in undivided India. Either of the parents born in undivided India. In that again, migrated to India before July 19, 1948. Why this date? Because that is when a permit system for such immigration was introduced. Been resident of India since migration. That is after coming from there. After July 1948, should have registered as citizen. Resident at least for 6 months before the date of application. Like very old rule. Very, very old rule. So that was the condition. Either you should have migrated before July 19, 1948 as per the permit system. If it is after July 19th, then you should have been residing here for 6 months at least before the date of application. That means, let us say I came in August. August 1st I came. August, September, October, November, December, January. 6 months completed. Now put the application. You have completed 6 months, now put the application. That is what it simply means. Clear, people? Moving on. Migrated to Pakistan after March 1, 1947, but later returned, can become citizen. Again, the 6-month condition. Migrated to Pakistan after March 1, 1947, because Mountbatten Plan. That is by that date. And again, the 6-month condition. What is the 6-month condition? You went there after March 1st, but then you came back. You are inside India for 6 months, then apply. Again, person was born in undivided India. Any of the parents or grandparents born in undivided India, but ordinarily residing outside India. is a citizen if he or she had been registered by a councillor representative in the country of residence before or after the commencement of the constitution for overseas Indians who may want to acquire Indian citizenship. These are the other conditions. Again, if you are born in undivided India, that is a person who is generally, let us say, is outside India. Okay, will also be considered to be a citizen of India if was born in undivided India. Any of the parent or grandparents were born in undivided India, but they are currently residing outside India, and is a citizen if he or she had been registered by a councillor representative in the country of residence before or after the commencement of the constitution. Simply means I am in USA. My parents were born in undivided India, or my grandparents were born in undivided India. All right. But right now, where am I? I am in USA. If I go to the embassy there, Indian embassy there, and I tell them that register my name as Indian citizen, I will be by default an Indian citizen. That is the idea here. Clear, people? Moving on. These provisions deal with persons domiciled in India, persons migrated from Pakistan, persons migrated to Pakistan but later returned, persons of Indian origin residing outside India. That is the beauty. You are inside India. You migrated from Pakistan. You went to Pakistan but came back. Finally, you are outside. These 4 conditions, whatever we saw till now, for all these 4 people, the earlier provisions, whatever we discussed, applies to them. Other provisions are not a citizen if he or she has voluntarily acquired citizenship of foreign state. Voluntarily, when you acquire the citizenship of, let us say, USA or any other country in Europe, by default, you stand to lose your citizenship. By default. Citizens are subject to the provisions of any law made by the Parliament. Parliament has powers with regard to acquisition and termination of citizenship. So, when it comes to making laws as to how can you become a citizen of India or how can you end up losing the citizenship, those laws are made only by the Parliament. And that is not mentioned anywhere in the Constitution. Clear, people? Taking it further forward. The Citizenship Act of 1955. So basically, I told you, Parliament makes the laws when it comes to how you can acquire citizenship. It is not mentioned in the Constitution. So Citizenship Act of 1955 basically talks about acquisition and loss of citizenship after the commencement of the Constitution. Citizenship Act 1955 provided for Commonwealth citizenship, which was repealed again by the Citizenship Amendment Act in 2003. Now, how can you acquire citizenship? First point is definitely by birth. Anybody who has their birth date between January 1, 1950 to July 1, 1987, irrespective of nationality of parents, they will be what? By default, if you are born inside India, by default you are what? Citizen. July 1, 1987 to December 3, 2004, if that is the date of birth, then you are a citizen if either of the parent is a citizen. Anyone. After December 3, 2004 means both parents and not an illegal immigrant, means both parents should be an Indian citizen and the person, either of the parents should not be an illegal immigrant. In such conditions, by birth, you are what? A citizen of India. Jan 1, 1950 to July 1, 1987. July 1, 1987 to December 3, 2004. After December 3, 2004. These are the conditions. Children of foreign diplomats and enemy aliens cannot acquire citizenship by birth. That is, even if, let us say, an ambassador of a foreign country, let us say USA, him and his family is staying here. His wife gave birth to a child. Can that child become a citizen of India? Absolutely not. Simple. Clear, people? Taking it further forward. By descent, born outside. January 26, 1950 to 10th December 1992. Anybody born between these dates. In such a condition, if father was citizen at the time of birth, then that child also becomes what? A citizen of India. If they were born outside, that is, let us say somebody who is working in Dubai, he was blessed with a baby girl. That girl by default is an Indian citizen. Why? Father is an Indian. That is the only reason. Born between which dates? January 26, 1952, 10th December 1992. After 10th December 1992 means if either of parents are citizen, that is enough. That is either father or mother. December 3, 2004, the next cutoff date. Not a citizen if not registered with Indian consulate within 1 year or with permission of central government after 1 year. So that simply means earlier rules were a little less stringent. Getting the picture here? Earlier it was, you're born outside India, but if your father is a citizen of India, that is more than enough. Second case, after 10th December 1992, if either of the parent is a citizen, that is enough. But after December 3, 2004, it is important that if a child is born to a parent or to a set of parents who are Indians, they have to register it with the Indian consulate within 1 year. And in case they are not able to do it, they have to take the permission of the central government after 1 year. In case they forgot about it or something, they need to take a permission. Only then citizenship will be granted to the child that has been born. A minor holding 2 citizenships will have to renounce the citizenship of the other country within 6 months of becoming a major to continue being an Indian citizen. Sometimes that happens. That is, let us say an Indian child born to Indian parents, but in USA. In USA, if you are born by default, if you take birth in USA, by default you become a US citizen. That is the general rule there. I know there are certain exceptions, etc. That is a different thing. But generally, you will end up becoming a US citizen if your child takes birth in USA. So now what? The child is literally having 2 citizenships. One by descent and one by birth. Took birth in USA, so you are entitled for citizenship in USA. Parents are Indians, so you are entitled to become citizen of India also. This you may hold as long as you are a minor, that is below 18 years. Once you become a major, you will have to renounce one or the other within 6 months after you turn 18. You will have to renounce one or the other citizenship. Clear, people? By registration, central government may register any person as citizen if they belong to the below categories. A person of Indian origin who has resided for 7 years before making an application for registration. 7 years you have been residing here. Now you present an application that I want to be registered as a citizen of India. You're allowed to do that. A person of Indian origin who is ordinarily resident in any country or undivided India. OCI card holder for 5 years. What is OCI? Overseas Citizen of India. And you have held that card for 5 years and you have been a resident in India for at least 12 months. In such a scenario, you are allowed to make a registration for citizenship. A person shall be deemed to be of Indian origin if he or she or either of the parents, were born in undivided India or in any territory which became a part of India after 15th August 1947. That is what you mean by person of Indian origin. Either you or either one of the parents were born in undivided India or in any territory after the date 15th August 1947. Such people will be considered as what? Persons of Indian origin. All the above categories must take an oath of allegiance before they are registered as citizens of India. Clear, people? Moving on. By naturalization. central government will grant a certificate of naturalization. See, naturalization happens if you have been staying in the country for a considerable period of time, as defined by the parliament or by the central government. And what are the criteria here? He or she is not a subject or citizen of a country where Indians cannot be a citizen by naturalization. That is the first condition. That is, whoever it is, a foreigner it could be, who is trying to apply for what? Indian citizenship. But it is important that the foreigner's country also should allow Indians to apply for citizenship through naturalization. Only then it will be granted. First condition. Second, has renounced the citizenship of another country after applying for Indian citizenship. So, if I'm a foreigner, I want to apply for Indian citizenship, the first condition necessary is for under naturalization is I should renounce whichever other country's citizenship I had, I should renounce it. Resided in India, been in the service of government in India or partly both throughout the period of 12 months immediately preceding the date of application. That is, I should have resided in India before at least for 1 year, or I have worked with the government of India, or partly, any of which, resided and partly I was in service of India, whatever, at least for a period of 1 year before I make this application for citizenship by naturalization. Next, during the 14 years immediately preceding 12 months, he or she has resided in India and has remained in the service of government of India or partly both for periods amounting in the aggregate to not less than 11 years. That simply means totally 14 years. Out of the 14 years totally, that foreigner, whoever it is, who was maybe under the service of government also, or just been in India, in the total period of 14 years, at least for 11 years should have been inside India. They could have gone out, etc. That is a different story. But at least the total time duration in the 14 years, before you put this application for citizenship by naturalization, at least for 11 years, you should have resided in India. The Citizenship Amendment Act of 2019 has reduced this aggregate period of residence or service of government in India to not less than 5 years. For the persons belonging to Hindu, Sikh, Buddhist, Jain, Parsi or Christian community in Afghanistan, Bangladesh or Pakistan. That is, its time duration has been reduced now to just 5 years. Instead of 12, the total aggregate can be 5 years. That you are either under the service of India or you have resided in India at least for a period of 5 years. Then you are eligible for citizenship by naturalization if you belong to any one of the religious minorities in Pakistan, Afghanistan, Bangladesh. And who are these people who are eligible for this now? Hindu, Sikh, Buddhist, Jain, Parsi or Christian community. The other conditions are he or she is of good character, has adequate knowledge specified in the 8th schedule, that is with regard to language. In the event of a certificate of naturalization being granted to him or her, he or she intends to reside in India or enter or continue in the service under a government in India or an international organization of which India is a member or under a society, company or body of persons established in India. Simply means they want to serve the country, either inside or outside as part of a larger organization. That is what it simply means. By incorporation of territory, if a foreign territory becomes part of India, then the people there also automatically becomes what? Citizens of India. Like this Pondicherry, Citizenship Pondicherry Order 1962 under the Citizenship Act of 1955. We saw this earlier. That is, if a territory was incorporated into India after 15th August 1947, then by default you become what? Citizen of India. Special provisions as to citizenship of persons covered by the Assam Accord. All persons of Indian origin who came before 1st January 1966 from Bangladesh to Assam are eligible for what? Being citizen. Between January 1, 1966 and 25th March 1971, they are detected as foreigner. by registration, they can become what? Citizen of India if they have spent 10 years and then they have filed the application. That is, they want to get registered as a citizen of India. Clear, people? This discussion, that is Citizenship Act 6A, this and the Supreme Court ruling has already been discussed by me in another channel, OnlyIAS Extended. Please visit that for more clarification. So let us look into the special provisions now as to citizenship of persons migrated from Afghanistan, Bangladesh or Pakistan. According to the Citizenship Amendment Act 2019, who are eligible for such provisions, such special provisions? They are basically Hindu, Sikh, Buddhist, Jain, Parsi or the Christian communities, basically the religious minorities who are being persecuted in Afghanistan, Bangladesh, Pakistan. And by what date? What is the cutoff date? It is December 31st, 2014. They are exempted from the penal consequences, that is the strict punishments of what? Passport, Entry into India Act 1920 and the Foreigners Act 1946. They are exempted from it. The central government may grant a certificate of naturalization on fulfillment of conditions of registration or naturalization. Any one of that. Getting the point here? Any one of the conditions of registration or naturalization, if it is fulfilled, means central government will issue a certificate of naturalization. Any proceedings of illegal migration will stand abated. Means what? If you would have entered as an illegal immigrant also, if you are a religious minority, you came before December 31st, 2014, you won't come under the penal provisions of it. That is, no criminal penalties that person will have to face. However, this is not applicable to tribal areas of Assam, Meghalaya, Mizoram, Tripura, and the areas covered under the inner line notified under the Bengal Eastern Frontier Regulation 1873. Again, to protect the tribal interests. So, that area, this will not be applicable. Now, we will move to the next topic, which is loss of citizenship by renunciation. As per the provisions of Citizenship Act of 1955, one can lose their citizenship. How? If you make a declaration. The next thing is what? You need to register the declaration. Fine. And a minor child born to such a person who has declared that, I have renounced my citizenship, even then also, that minor child also loses Indian citizenship. However, central government can withhold this declaration, this renunciation or declaration, whatever you have made, can withhold that registration if war is going on. They will hold it. Similarly, by termination, if you acquire the citizenship of another country voluntarily, by default, you will end up losing Indian citizenship. Again, this provision will not apply during war. By deprivation, compulsory termination of Indian citizenship by central government. That is, this is not like renunciation, or this is not like going and voluntarily taking the citizenship of another country. This is like termination from the central government. How? The citizenship has been obtained by fraud. Disloyalty is shown to the Indian Constitution. That is, you basically committed an act or something which goes against the fabric of the nation. Unlawful trade and communication with enemy during war. Within 5 years of naturalization or after registration has been imprisoned in any country for 2 years. That is, after you got your citizenship registered or naturalized, you were imprisoned at least for 2 years in any other country. You will lose citizenship. Ordinarily resident out of India for 7 years continuously. For more than 7 years, you are residing outside India, then your citizenship can be deprived by the central government. Overseas citizenship of India. This OCI and NRI, again, these are two provisions where there was a lot of confusion. Persons of Indian origin, OCI, NRI, lot of confusions were there. So finally, government brought in some clarity to it. So let us just briefly go through its history. September 2000, a high-level committee under L.M. Singhvi was appointed to conduct a comprehensive study of global Indian diaspora. January 2002, the said committee recommended giving dual citizenship by amending Citizenship Act of 1955 to the persons of Indian origin belonging to certain specified countries. CA 2003, acquisition of OCI by PIOs. OCI, overseas citizen of India. PIO, persons of Indian origin, by 16 specified countries other than Pakistan and Bangladesh. Omitted all provisions relating to the Commonwealth citizenship from the Principal Act. CAA 2005. The above provision was made applicable to all those countries which basically allowed for what? Dual citizenship. Simply means you will be given, you are staying abroad, you will be given an OCI card. You are an OCI card holder in all those countries where dual citizenship is allowed. So does that mean India allows dual citizenship? Absolutely not. India does not allow dual citizenship. It is just that you are abroad, you hold this OCI. So PIO and OCI got merged. When? OCI is not dual citizenship as it is forbid under Article 9. Citizenship Amendment Act of 2015 merged OCI and PIO, Overseas Citizen of India cardholder. Now that is the only terminology that is available. Getting the point here. Overseas Citizen of India cardholder. You are a citizen of India, but where are you? You are abroad. That is the meaning today. Committee has actually recommended for dual citizenship, but it is a clear violation of the constitution. And there was always confusion between PIO, NRI, OCI, etc. So finally what the government did? Merged PIO and OCI together, and today there is only one terminology, OCI cardholder, from 2015 onwards. Getting the point? Taking it further forward. So the PIO scheme was brought in the year August 19th, 2002. OCI December to 2005. PIO cardholders deemed to be OCI cardholders with effect from January 9, 2015. That is from January 9, 2015 onwards, both these have been merged and now only you have one terminology, OCI cardholder. Registration of Overseas Citizen of India cardholder. The central government may register any person as OCI cardholder, any person of full age and capacity who is citizen of another country but was the citizen of India at or after the commencement of the constitution. Citizen of another country but was eligible to become the citizen of India at the time of commencement of the constitution. Citizen of another country but belonged to a territory that became a part of India after 15th August 1947. Child or grandchild or great-grandchild of such a citizen. Getting the point here, people? It almost looks as if it is like dual citizenship, but it is not. Is a citizen of any person of full age and capacity who is citizen of another country, but was the citizen of India at or after the commencement of the constitution. Citizen of another country, but was eligible to become the citizen of India at the time of commencement of the constitution. Citizen of another country, but belonged to the territory of India, which was incorporated after 15th August 1947. Child, grandchild, or great-grandchild of such a citizen. A person who is a minor child of the above person mentioned in clause A. A person who is a minor and both or either parents are citizens of India. Spouse of foreign origin of a citizen or spouse of foreign origin of OCI cardholder, and whose marriage has been registered and subsisted for a continuous period of not less than 2 years immediately preceding the presentation of the application. So, what does this mean? Wife is a foreigner or wife of an OCI cardholder, at least for a period of 2 years before presenting the application. That means a foreigner is also entitled to become an overseas citizen of India. Conferment on rights of OCI cardholder. the central government can specify what all rights are available to the OCI card holder. However, they are not entitled to equality of opportunity in matters of public employment, Article 16. Not entitled to be registered as a voter. They cannot be they cannot take part in the election as president, vice president, to be appointed as judge of Supreme Court, judge of High Court, being a member of Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council. Appointment to public services at center or state, except in those services as specified by the central government. That means basically no public offices, no constitutional posts, and they cannot entitled to be registered as voter also. They don't have voting rights. Clear, people? Renunciation of OCI card. You can renounce it by declaration, just like citizenship. Even spouse of foreign origin and minor child loses OCI card holder status. That is the point. That is, if I'm an OCI card holder, I renounce this. My wife ends up losing it. My child also ends up losing it. Cancellation of registration as OCI card holder. Registration obtained through fraud, false representation, or concealment of any material. Shown disaffection towards the constitution. Communicated with enemy during war. Within 5 years after registration, you're imprisoned for at least 2 years. Almost the same conditions of deprivation. Clear, people? Violated any provision of the law or Citizenship Act of 1955 added by Citizenship Amendment Act of 2019. Necessary for sovereignty, integrity, security, friendly relations, interests of general public. On that grounds also, OCI can be denied. Marriage has been dissolved or married again without dissolving the first marriage. That simply means your first wife is still there. And that was not dissolved. And you went on to marry one more time. In that case also, the OCI is lost. Reasonable opportunity to be heard will be provided as per CAA 2019. That is, it is not that the central government will unilaterally decide this. An opportunity will be given to defend that particular OCI cardholder's position also. Getting the point here? It is not a unilateral decision. And this provision was again added by the Citizenship Amendment Act of 2019. With that, we wind up this chapter. Let me tell one simple thing here. Just read through this chapter. Especially that 6A, that is what is most important. Please visit the OnlyIAS extended channel to know more about it. Alright, otherwise this chapter, just go through it. Importance, if you ask me, it is very, very, very less. Alright, so let's call it a day, people. Any further suggestions or queries, please contact me in the Telegram channel. Have a fantastic day. Take care.